So, Elizabeth, are you starting?
Hello, everybody. Welcome. I see that we have a lot of people still joining. And so we had budgeted our time a little bit to have people come in. So I'll wait 1 minute and then we'll get started. Hello, everybody. Welcome. It's wonderful to see so many faces with us today. My name is Elizabeth Cullen. I'm the Associate Director for Health Policy with the Strategic Health Resource Center for the Jewish Federations of North America. And I wear two hats, the Washington representative for the Network of Jewish Human Service Agencies. And this is a presentation to both an NJHSA audience as well as our Federation and community audiences across the country. First of all, I want to say that we're incredibly grateful to the Jewish Federations of North America's Strategic Health Resource Center for hosting this call, since the Supreme Court's decision in the Dobbs v. Jackson Women's Health case overturning the constitutional guarantee of abortion. Jewish Federations has been working hard to reach out to our communities throughout the country to assess their needs and fully understand the ramifications for the women, girls, and other pregnant individuals, as well as for our federations and partner agencies and their staff. Today's program actually originated with concerns being expressed by clinicians providing mental health services for Jewish family service agencies. And we're incredibly grateful to the network of Jewish human service agencies Clinical Net Group for allowing us to hold today's program during their regularly scheduled meetings so that clinicians from across the country are able to participate. And so many of them have joined us today, and we're delighted about that. Then as this program developed, we realized really we wanted to open it up to Federation volunteer leaders and professionals who are working to meet the needs of our communities, and who also wanted to learn more about the legal risk exposure from the Dobbs decision. And we're delighted that so many of you are able to be here today. So before we begin, I actually want to introduce a few people on the call. I want to tell you about Jonathan Weston, who's going to join us a little bit later, who is the Senior Director for the Strategic Health Resource Center at JFNA. And the mission of the center is specifically to sustain the work of our partner agencies like the Jewish Family Service Agencies. Also, I want to call out Ruben Rotman, founding president and CEO of the network, as well as Tricia Stern, Vice President for Child and Adolescent Mental Health Services with the network, and Lisa Lorraine Smith, who's the Chief Program Officer for the network. So all of these individuals helped put together this program and really helped bring the network's clinicians and our community leaders together. And we're very grateful for this opportunity. And last but not least, I want to introduce you to our wonderful moderator for today's discussion, Bob Yass. Bob co-chairs Jewish Federation's Health and Long-Term Care Committee, as well as serving as JFNA trustee and a member of its Domestic Policy and Government Affairs Council. But Bob's not just active at the national level, he's been active in his home community where he served as chair of the Jewish Federation of Greater Hartford and continues as a current board member and was past chair of the Jewish Federation Association of Connecticut and director and secretary of the Jewish Council for Public Affairs. Now, in his spare time, Bob is and was an attorney and worked as a government affairs executive in the insurance industry. And he now teaches at the University of Connecticut Law School and clearly doesn't understand the meaning of the word retirement. So Bob, I turn the microphone over to you to lead us in this critical conversation as we take a deeper dive into the legal risks in a post-Dobbs world. And I do want to ask folks to mute your lines if you're not speaking. Thank you so much.
Thank you, Elizabeth. On June 24th, the United States Supreme Court issued its decision in the Dobbs versus Jackson Women's Health Organization matter. and rescinded the constitutional right to abortion. The decision reversed the court's longstanding earlier rulings in Roe versus Wade in 1973 and Casey versus Planned Parenthood in 1992, overturning nearly half a century of legal precedent. Emboldened by the court's decision, many states have moved rapidly to ban or further restrict abortion. According to the Guttmacher Institute, which tracks abortion laws, as of September 5th, abortion is illegal from conception or 6 weeks of pregnancy in 13 states. Meanwhile, court injunctions are temporarily blocking bans in still more states, and experts are predicting that 26 states ultimately will ban abortion. The state abortion bans are having large-scale, real-world consequences already. Based on census data, the Washington Post recently reported that nearly 21 million women and girls between the ages of 15 and 44, 1 in 3, have lost access to nearly all abortions in their home states as a result of the decision, and millions more will lose access as additional abortion bans are enacted or take effect. Also, as a result, reports are proliferating about patients experiencing miscarriages and patients with non-viable or dangerous pregnancies who are being forced into life-threatening medical conditions before they can receive medical treatment. People carrying fetuses with serious abnormalities or genetic defects are being forced to travel to another state to access abortion care. People with serious medical conditions are being denied life-saving medications and treatment if these treatments pose a potential danger to the fetus. Serious pregnancy complications are on the rise, and access to contraception is decreasing as well. Further, in states with abortion bans, providers of reproductive health services are being forced into extremely difficult situations where they risk substantial criminal and civil penalties in caring for their patients. And it's not only providers of abortion care who are concerned. As Elizabeth mentioned, a major reason for today's call is that many supporting healthcare providers not directly providing abortion care, such as clinicians working for Jewish family service agencies, are concerned about their own legal risk exposure. This landscape is changing fast with state laws that vary greatly, causing significant uncertainty for patients, providers, Jewish family service agencies providing behavioral health care, Jewish family service agencies and federations providing or thinking about providing financial assistance, and organizations as employers. We are therefore extremely fortunate to be joined today by two top lawyers with the national law firm of Holy Hoag, the JFNA Strategic Health Resource Center's outside regulatory counsel, who are here today to provide a realistic assessment of the legal risks and answer as many questions as they are able, recognizing, of course, that many of our questions may have no answers yet. Therefore, it is with great pleasure that we welcome Tom Barker, senior partner at the firm, who co-chairs their healthcare practice and has special expertise on Medicaid and Medicare. Prior to joining Foley, Tom served in several senior level positions with the federal government, including as general counsel of the U.S. Department of Health and Human Services. We are also delighted to be joined by Tom's partner, Kristen Bunce DePhillip, who co-chairs the firm's litigation practice, with a particular focus on litigation relating to healthcare, labor, and employment, among other matters. Before joining Foley, Kristen served as a special assistant district attorney for Norfolk County in Massachusetts. Elizabeth has put their full bios in the chat in case you're interested in reading more about them. And just a few process reminders. Again, if you have not yet, please mute your lines unless you are speaking. Please share your questions in the chat box. We've asked Tom and Kristen to provide a legal overview for about 20 to 30 minutes. We will then turn to Dr. Elaine Rotenberg, Chief Clinical and Impact Officer for the Albert Jewish Family Service of Palm Beach County in Florida, who also chairs the network of Jewish Human Service Agencies Clinical Net Group. Many of the people attending the meeting today are clinicians who work for our partner Jewish Family Service Agencies throughout the country. Elaine will kick off our discussion with a couple of questions that are most concerning to the clinicians. And if we have time after that, we will field as many questions as we can in the time remaining. So Tom and Kristen, turning it over to you.
Thanks very much, Bob, and thanks to everyone from JFNA for joining on the call today. Kristen and I are really happy to have this opportunity to speak to you today. As Bob mentioned, the Dobbs decision has created a host of legal issues for healthcare providers that we've been grappling with at the firm for our clients. Shortly after the decision came down, we made a strategic decision at the firm that we would form a reproductive health practice group. My colleague, Kristen DePhillip, and I are both partners in that practice group. I'm going to maybe start off. Bob was very generous to give us both a very nice introduction. I'll let Kristen introduce herself very quickly. Then I'll introduce myself. We'll both have a few overarching remarks, and then we'll dive into the substance of the call. But Kristen, let you introduce yourself first.
Great. Thank you, Tom. And thank you to JFNA for having us today. Obviously, this is a difficult conversation, both legally and sort of from a policy perspective, but one we're happy to help with. My name is Kristen DePhillip. I am a partner in Foley Hoag's Boston office, and I am the co-chair of the litigation department. My practice focuses on litigation and investigations relating to healthcare, and that runs the gamut from everything from ERISA preemption related impact litigation to enforcement activity against healthcare providers. Tom, did you want to provide a brief additional background for you, and then I'll jump in?
Sure. And as I said, my name's Tom Barker. I'm a partner in the healthcare practice. As I mentioned, I am based in our DC office, although at the moment, as I speak to you, I'm actually in our Boston office today, but I'm normally in our Washington, DC office. I've been a healthcare lawyer at the firm for 14 years. Prior to that, as Bob mentioned, I was the chief legal officer of the Centers for Medicare and Medicaid Services, and I was the general counsel of the Department of Health and Human Services. Our goal on this call is to highlight some of the topics that we have been grappling with as attorneys in the Reproductive Health Practice Group, identify issues that may be facing JFNA members, and anticipate potential steps that might be taken by the Biden administration and the courts to bring some degree of clarity to providers. But as Kristen mentioned, this is a difficult conversation to have for many reasons, one of which is there isn't a lot of clarity right now. Things are changing very rapidly. Kristen, let me turn it over to you to make a few additional comments, and then so the way we're going to do this call is Kristen and I are going to divide up a series of topics that we have addressed. So let Kristen make some overarching comments, and then she's going to dive in on the first issue, which is responding to information requests. So Kristen, I'll put myself on mute right now and turn it over to you.
Thank you, Tom. So as Tom said, as Bob previewed, this is a rapidly developing area of the law. And so while there are not always black and white answers to all of the types of the legal questions that you're grappling with, and there also are questions whose answers may be changing rapidly. For example, where you have state abortion laws that are being challenged in court, whether or not access is available or liability is possible in a particular state can literally change on a day-to-day basis. So we're going to do our best to answer your questions and give you an overview. I think Bob framed it right when he said this is really a way of thinking about risk assessment in this space, because you do not have necessarily clear answers about what is or is not going to get anyone in trouble of any kind, what is or is not definitely okay. So what we can advise you on is how to weigh those risks, how to mitigate the risks, and kind of where we're seeing things sitting here today. And the other thing to think about is that, when you are presented with some of the scenarios that we'll be discussing, hopefully what we'll talk about today will help you understand when to get counsel, maybe what kind of counsel to be seeking, and how to frame the issues for your counsel as you provide more fact-specific advice, as you pursue more fact-specific advice. So the first topic that I wanted to touch on before I turn it back to Tom is the topic of the question of when is a healthcare provider obligated to, prohibited from, or when should they or can they provide information about patients in their care or previously in their care to third parties. So the issue of requests for information is one that we've been receiving a lot of questions about from clients. And before diving into sort of what do you do if you get a request for information, it's important to note that there are many different forms that a request for information could take. It could be anything from, a trial subpoena to come testify in a court, to a civil investigative demand from a federal or state agency, to a request from a private litigant in a civil litigation, such as a civil subpoena, to a search warrant, or a request to preserve information. So there's many different types of requests that you may receive. None of this is necessarily unique to the reproductive healthcare space. These are the types of requests for information that parties can receive all of the time. And they could come to you via email, they could come to you via process server, or via mail. There's many different ways that this could come your way. But your obligation to provide patient information in response to any of those requests is going to depend on several different factors. So the first factor is, what is your connection to the state where the request originated? And this is an important factor that is going to have issues that play a role in many of the topics we're discussing today. So as we know, the Dobbs decision took what was once a federally protected right, the federally protected right to obtain an abortion, and ended up delegating the decision of whether or not patients have the right to an abortion or providers have the right to provide an abortion to the states. So what was once an issue of federal law is now an issue of state law. And as Bob previewed, sitting here today, about a quarter of the states have already acted and are sort of actively enforcing abortion bans of one kind or another. There's probably about another quarter of states that have those bans in motion in some fashion. Maybe they're on the legislative books, but being challenged in court. Maybe the language of a statute is still being worked out among the legislature, or it's anticipated in the next legislative term. But we are now in a world where the question of whether someone can get an abortion or whether a provider can provide an abortion is potentially has 50 different answers to it. Which is part of what makes providing advice on this topic so very challenging, because there's many different characters or flavors of abortion bans. So if you're assuming you're in the position where you're a provider in a state where abortion is legal and you are getting a request, whether it's a search warrant or a subpoena or a civil subpoena that originates out of a state, some other state where you do not reside, there are defenses that you may have based on your connection with that state. The other big issue is that there are many developing arguments right now about a state's ability to enforce its own laws on residents of another state about conduct that's happened in another state. So I think sort of the quintessential hypothetical that people are thinking of is a pregnant person in a state that's hostile to abortion, leaves the state, goes to a state where abortion is legal, obtains an abortion from a provider in that state, and goes home. And so what can possibly happen with a provider in that state? One of the ways this plays out is in these requests for information. And while I wish I could give you a really clear answer about what the risk is for providers sitting in the state where abortion is legal and potentially providing care to residents of other states, all I can tell you is that it's not 100% clear. The issue of extraterritoriality, the issue of to the extent to which a state can impose its laws on other states, is a complicated one. It has federal constitutional implications, and there's many different arguments that the parties on both sides can make. And it's one that I think is probably the most likely to be determined by courts around this country in the coming years, because it's basically one of the hot button issues of abortion access right now. And there may be inconsistent law coming out of different courts in this country. So what we can advise you on are sort of defenses that you can raise, assuming you're one of the providers in that position of being in a state where abortion is legal and dealing with a state where it's not. And one other note on that, which is that I think one of the reasons why this hasn't played out yet, while we don't know the answers to these questions yet, is because of the unique character of abortion and the unique character of some of the laws that have been passed in recent months, and including the Texas law that was passed actually before the Dobbs decision that empowers private citizens with the right to enforce the abortion ban in that state. So in many instances, when you're talking about conduct that's illegal in one state but legal in another, and I think, you know, two of the examples that people often think of is like the use of marijuana and maybe gambling would be another one. Okay, so in most instances, if you don't have a civil right to enforce your laws, everything is going to be subject to law enforcement's own prerogative. So the police in, you know, Oklahoma might not care much about what's happening in Nevada. And so you're not going to have a lot of activity to try to force a law from one state on another state. But this is different when you have abortion and you've empowered private citizens, because it's obviously a deeply personal issue to many people. It's an issue that people feel very passionately about on both sides. And when you have private citizens who are not subject to sort of the policy considerations that perhaps a law enforcement agency would be subject to, you can get some sort of strange results. So that's the sort of overarching issue of extraterritoriality, which plays a role in many of the other questions. Getting back to other issues that might be posed by the receipt of one of these requests for your patient's information, another thing to consider is what type of request is it? Is this a search warrant? Is this a subpoena issued out of federal court? Is this a letter from some private citizen who just wants the information? Your approach to responding to the information is going to be different depending on what the form of the request is. And I would just say, you know, do not assume if you receive a request that you have a legal obligation to respond to it. It really, if you do receive a request like this, you should be consulting with counsel. For example, a request from law enforcement is likely going to have more force than a request from a private citizen, and a request originating out of federal court is likely to be treated differently than a request originating out of state court. Another key question when considering what your obligations are is not what state it originates from, but what state are you sitting in today? Many of the states that are pro-choice, many of the deep blue states, have enacted legislation that protects its residents from having to respond to these types of information requests. And that legislation is going to vary state by state, or the efficacy of the legislation is likely to vary state to state. So I sit in Massachusetts. This is one of the examples of a state that has, you know, really, I think, done the most it can possibly do to protect providers in this state from having to turn over sensitive patient information and from potentially opening themselves up to potential liability. We have legislation. It has broad protections in it relating to what is defined as legally protective health activity, and that includes reproductive health care as well as gender affirming care. Just kind of anticipating another medical related issue coming down the pike. So in Massachusetts, we have a law that says Massachusetts courts are not going to enforce subpoenas from other states about legally protected health care, and they will not issue subpoenas from other states. I think it remains to be seen how effective this is going to be. We expect that there are going to be challenges to this statute, but if you're in a state that has enacted one of these shield laws, then you are much more likely to be able to defend yourself against a request for this kind of information. Another consideration would be the HIPAA privacy rule. So in response to the Dobbs decision, HHS issued some clarifying guidance on the privacy rule and disclosures of information relating to reproductive health care. And the guidance is basically that a covered entity is permitted but not required to disclose the information as required by law or for law enforcement purposes. But this is a somewhat limited defense because it defers to the covered entity's judgment in the face of a lawful information demand. So where there is a valid subpoena that's issued under state law, it's unlikely that HIPAA offers full protection from your ability to disclose it. But it can be helpful in combination with the shield laws that I am describing, such as in Massachusetts. And then one other issue relating to information requests, and this is again not specific to reproductive health information, there's many ways to sort of mess up issuing one of these requests for information. So a subpoena or a warrant could be legally or technically deficient. And so there really are sort of a cascade of options that you might have to respond to one of these subpoenas. And I think it is important to get counsel involved if you do receive some form of request for information, and they can advise which, if any, or if all of these potential defenses could inform your response. So the short answer to the question of, do I have to turn over my patient's information, is definitely, it depends. You're probably in a better position if you're in a state that's enacted a shield law. And you may have arguments, even if you're not, about extraterritoriality and jurisdiction, but it's something that is fairly state and fact specific. Tom, turn it to you.
Thanks, Kristen. The next topic that we wanted to discuss is one that's come up from a lot of our hospital clients, and that is the interaction of the Federal Emergency Medical Treatment and Labor Act, EMTALA, and state laws, especially in states where abortion is now illegal. The EMTALA statute essentially entitles any individual who comes to a hospital emergency department to a medical screening examination to determine whether or not an emergency medical condition exists. So an individual is entitled both to the screening exam, and then if there is a determination that the patient has an emergency medical condition, the hospital has an obligation to either stabilize the medical condition or to provide for an appropriate transfer in situations where the hospital doesn't have the capability to provide the stabilizing treatment. So this is an issue, right? If a pregnant woman comes to a hospital in a state where abortion is now illegal, and she's suffering a medical emergency that is related to her pregnancy, and the physician, either the emergency physician or the OBGYN on call, concludes that the appropriate medical treatment to stabilize the medical condition is an abortion, what are the dueling obligations there? So on the one hand, the hospital and the physician have an obligation under EMTALA to provide a screening exam and stabilizing treatment. On the other hand, there's a state law that potentially criminalizes abortion. How should the physician respond? And I'll just point out as an aside here that these are not decisions that that clinicians have the luxury of being able to pontificate about and think about. These are decisions that are happening right now, in the moment, life and death decisions that have to be made where the physician doesn't really have time to consult the hospital's general counsel. So how should a hospital respond? The Biden administration issued guidance very shortly after the Dobbs decision came out that took the position that EMTALA preempts state law. And if the appropriate treatment for an emergency medical condition is to provide an abortion, the hospital has an obligation under federal law to provide that procedure. I'll point out that there have been 2 lawsuits since that guidance was issued. Texas filed litigation proactively seeking a determination that the guidance was illegal on several grounds. First, that it wasn't issued pursuant to the required process. Also because Texas argued that HHS misinterpreted the EMTALA statute. Similarly, at around the same time, the federal government filed a lawsuit against the state of Idaho, arguing that Idaho's anti-abortion law was preempted by ERISA. And Kristen started off this discussion by noting that there are gray areas in the law. Here's a perfect example. Texas ruled one way, Idaho ruled the other. The Texas court ruled that the Texas Attorney General was right, that the guidance was improper. The Idaho court ruled that the guidance was proper. And so we now have a conflict between 2 federal courts. In theory, the Justice Department could appeal its loss in Texas. The Idaho Attorney General could appeal its loss. to the US Court of Appeals for the Ninth Circuit. There may wind up being a conflict in the circuits. This issue may go to the Supreme Court. But it is an issue that we're following closely. And for those of you who practice in hospitals, it's something to be aware of. So I'm going to turn it back over to Kristen now to talk about a really interesting issue about health plan benefit design. And then she's going to turn it back to me, and I'm going to talk about benefit design in the Medicaid program. But Kristen, let me turn it to you first.
Great, thanks, Tom. What we've just been talking about is the perspective of potential liability from a provider's role as a provider. I'm going to pivot a little bit and talk about employers and their potential exposure and what they may or may not be able to do relative to covering employees' abortions as part of their healthcare benefits. So many employers with employees in states where abortion is now banned would like their employees to retain access to reproductive care, including abortions. And so it's becoming more and more common to see employers looking for paths forward to provide coverage for out-of-state travel and healthcare. The primary concern that this poses for employers is, could I potentially be liable under a state law that prohibits aiding and abetting abortion? The Texas law prohibits aiding and abetting abortion. Oklahoma also has a law in place that prohibits aiding and abetting abortion. I think it's likely that to the extent the other bans in place haven't been interpreted that way, some of them will go in that direction as well, or may receive clarification from the legislature. So I think there are probably a variety of ways that employers can provide the benefit to pay for out-of-state travel and care. And employers can attempt to protect themselves by both reducing their reducing their knowledge of the specific circumstances in any individual employee's case. So aiding and abetting liability is going to require you to know what you're helping to accomplish. And retaining, the second issue would be trying to retain a ERISA preemption defense to any state action against the employer. So first, the knowledge issue. So aiding and abetting liability, whether it's criminal or civil, would generally require knowledge of an unlawful act. So if the employer is providing a benefit that can be used for an out-of-state abortion, but doesn't necessarily have to be used for that, and maybe isn't limited to that, the employer has an argument that we don't know what we're abetting or aiding. We're just providing healthcare benefits to our employees who need to travel out of state. But that can be mechanically difficult, right? So how do you insulate yourself from knowledge? There's a few different ways you could do that too, that I can think of would be you offer some sort of generic travel benefit that doesn't require any sort of substantiation of the need for the travel benefit or the need or what you did with it. And then another alternative would be to use a third-party administrator that doesn't report actual care-related information to the plan, but rather reports some sort of high-level summaries to the plan. So now that might potentially create liability for the administrator, but we're thinking about standing in the shoes of the employer here. And so if the employer does not know what they are doing, that should help. I just want to make one more note on this idea of knowledge and the aiding and abetting liability. And this gets back to what I was saying about the state to state differentiation of these laws and the increased risk provided by what's happening right now. Because these are state laws, and some of them are enforced by private citizens rather than law enforcement. Again, the definition of what someone would consider aiding and abetting or someone would consider knowledge may vary state to state. And it is possible that you could get like a rogue state court judge who decides that paying for it, even if you didn't know what it was, is aiding and abetting. Now, would that decision be held up on appeal? Maybe not. But I think one of the big problems that both providers and employers are facing now is the decision-making is so dispersed and there's so much opportunity for inconsistency that the risk is still there kind of no matter what. You can tick all these boxes, but that doesn't mean it won't create a nuisance for you. So, again, nothing that we're saying is going to perfectly insulate an employer from a claim that they're aiding and abetting, but it could give you a better defense to that claim. So the second issue is ERISA preemption. So ERISA is a federal law that preempts state laws that interfere with employee benefit plans. And this is obviously, for those of you who have any familiarity with ERISA, I just way oversimplified it, but basically it is, it is the federal law that dictates the provision of employee benefits, whether those are pension benefits or health benefits. All employee benefit plans are covered by ERISA. And there is a very robust body of case law that has interpreted the preemption clause of ERISA, which is the clause that says, federal law governs here, not state law. States stay out of this realm of employee benefits. So ERISA makes it so that states cannot interfere with employee benefit plans, and especially with those plans' benefit design, such as what types of things are they covering. Because this arises out of a federal statute, the states can't do anything really to change this preemption law, but they may act to try to toe the line of it. So when a federal government is saying states, you can't do this, that means state law enforcement officials can't criminalize the benefit design that an employee plan is implementing. However, there is a limitation, which is that ERISA preemption generally only applies to self-funded employee plans. So if you are an employer and you fund your own employee benefits, rather than purchasing insurance on behalf of your employees, you can raise the ERISA preemption argument against the state efforts to criminalize or otherwise make illegal the benefit structure that you're trying to offer. And again, this is a risk mitigation issue. It's possible that a state may still pursue action against an employer plan, but the ERISA preemption would be a defense that you would raise in response to that. Okay, Tom, benefit design in state Medicaid plans. Over to you.
Thanks, Kristen. So shortly after the Dobbs decision came down, you may have seen that President Biden signed an executive order. He signed several executive orders, but one of them directed HHS to take steps to determine whether or not changes could be made to Medicaid's benefit design to facilitate travel of a Medicaid beneficiary who lives in a state where abortion is illegal to travel to a state where abortion is legal. So let's just use, for example, Oklahoma and Massachusetts. Oklahoma Medicaid beneficiary, pregnant, wants an abortion, decides to travel to Massachusetts. Can Massachusetts Medicaid cover the travel expenses? So the executive order was merely a directive to HHS to issue guidance. HHS has not done that yet, but we anticipate, not entirely clear yet, but my guess is that HHS will say that Medicaid's non-emergency medical transportation benefit, which was codified and added to the Medicaid program back in 2020, in December of 2020, that benefit, it goes by the acronym NEMT, non-emergency medical transportation, that the NEMT benefit could be used to pay for out-of-state travel. It's not clear to me how that's going to play out, and it raises really a lot of very interesting questions. So for example, surely Oklahoma Medicaid is not going to pay for a pregnant woman in Oklahoma to travel to Massachusetts. That much is clear. But can Massachusetts Medicaid pay for the travel from that Medicaid beneficiary in Oklahoma to Massachusetts? Another interesting issue is surely Oklahoma Medicaid is not going to pay for the abortion for the Oklahoma resident who's traveled to Massachusetts. But can Massachusetts Medicaid pay for it? There's also the question of the Hyde Amendment, which generally prohibits Medicaid from paying for abortion, but a state can fund it on its own. Will Massachusetts be able to do that? So these are issues that are going to have to be worked out both at the CMS level and also individual state levels. And states are also going to have to consider, for example, do they need to get a waiver? Do they need to revise their state plan amendments? All of these issues need to be worked out. But for those of you on the call who see Medicaid beneficiaries for whom Medicaid is paying for their care. This is something you may get questions about as time goes on. So it's worth paying close attention to what happens in this area. I'll point out that we at our firm, we have a Medicaid blog, and once guidance comes out in this area, we'll be publishing on it. And so actually, you know what, Elizabeth, how about when I turn this back over to Kristen, I'm going to send you the link to our blog, and maybe you can post it in the chat box so that folks can see the URL for our Medicaid blog. But that's a good place to stay on top of what's going on in the Medicaid area. So there are two more issues that we want to talk about that there's not quite as much to share because there's just not yet a lot to say. Kristen's going to talk now about state pharmacy laws with regard to dispensing of medications that can be prescribed to induce an abortion. And then we're going to turn it back to me to talk about telehealth. But let me turn it to Kristen now.
Great. So I will go quickly here because I know we're running low on time, but I think just one other area of law to keep in mind is that there are pharmacy laws in addition to, you know, other state laws. There's going to be state pharmacy laws potentially, also, you know, regulations or other guidance issuing from state boards of pharmacy to keep in mind, because so many abortions are medication-induced abortions at this time, and there is a wide variety of law on this. So during the pandemic, the FDA has obviously cleared the use of certain drugs to induce abortion or to terminate pregnancy. Some of those drugs have other uses as well. And one of the significant sort of concerns that was raised after the Dobbs decision was access to those drugs for other issues, other uses. But even before that, and before Dobbs, FDA had removed the requirement that the drugs be dispensed in a doctor's office. So you can go to, you know, assuming abortion is legal in your state, you can go get an abortion pill from a pharmacist at a retail pharmacy. After Dobbs, there became the issue of restricted access to these drugs. And if you're a provider who's prescribing one of these drugs for another condition, I'm sure this is a concern that you've had because the state laws were sort of then emboldened to allow pharmacists not to dispense drugs for abortion if abortion was illegal. There was the concern that they would just stop dispensing these drugs altogether. So in July, HHS issued some guidance to retail pharmacies that are recipients of federal financial assistance, including Medicare and Medicaid, and just reminded them that they do need to supply prescribed medications without discrimination, and sort of reiterated all of the different protected categories of people that are entitled to protection from discrimination. And I think, you know, one of the underlying purposes there is this idea that just because something can be used as an abortion drug doesn't mean you can just stop providing it to somebody who may need it. So you have that issue with FDA clearance and FDA authorization of dispensing this drug. And then you have the HHS guidance, and then all of that is sort of interwoven with the state pharmacy laws. So there isn't really like huge takeaway advice here, other than to say that there are lots of different state laws that could influence a pharmacist's ability to dispense these drugs. Some of the abortion bans or abortion restrictions are going to influence what type of pharmacy can dispense the drugs and when. That can obviously lead to questions and sort of pharmacists having to make decisions on the fly about, you know, basically how many weeks far along is somebody when they're seeking to get the prescription filled. Some of the states are requiring that any abortion, even medication-induced abortion, take place in a hospital after a certain point in time. There are, you know, freedom of conscience laws that allow pharmacists to refuse to dispense certain drugs. And different states are going to have different rules about what that pharmacist must do when they're refusing to do so, if they have to find the patient another provider, or if they have to, or if they're allowed to just kind of slam the door in their face. There are non-resident pharmacy licensing laws. So if you're mailing medication to another state, you have to consider whether you need to be licensed as a non-resident pharmacy in that state. And if that state is a state with an abortion ban, then you need to be thinking about, are you meeting the licensing requirements to be a pharmacy in that state? The counseling requirements that are inherent to many abortion restrictive laws could be imposed on a pharmacist who is the provider delivering the abortion care, as could the waiting period requirements. So there's a whole host of issues that need to be considered in the context of medication abortion. And there is both, you have to consider both the federal and the state framework there. Okay, back to Tom for description of telehealth, other telehealth issues, which telehealth and medical abortions are obviously closely related.
Thanks, Kristen. So this is the last topic that we wanted to discuss, and then we'll turn it over for questions. So the issue here is, to what degree are there flexibilities or abilities in the Medicare and Medicaid programs to provide for telehealth in reproductive health services? During the pandemic, there were significant flexibilities that Congress created and that CMS created to ease access to telehealth for Medicare beneficiaries. So probably not a lot of Medicare beneficiaries need reproductive health services. It's possible, of course, but not all that common. But more to the point, a lot of states also adopted flexibilities in their Medicaid programs to ease restrictions on the provision of telehealth services. Of additional note, a lot of states took advantage of those flexibilities to liberalize their state practice of medicine regulations. So, for example, to allow a Massachusetts doctor to provide a telehealth service to a patient in Oklahoma, for example, where she's not licensed to practice medicine. The issue with telehealth that we see is that a lot of these flexibilities are going to go away when the public health emergency ends. It's probably not going to happen for another few months, but at some point, a lot of these flexibilities will go away. In the case of Medicare, they're going to go away by law, because the flexibilities that are in effect are only in effect because CMS has agreed to waive the law during the public health emergency. I think a lot of those similar dynamics will play out in state Medicaid plans. So this is something to keep an eye on as the public health emergency comes to an end. My guess is that we will see some flexibilities remain in Medicaid and Medicare, but we're going to have to see how things play out. But it is certainly possible that some reproductive health services can be provided to an out-of-state resident via telehealth. We will just have to see how long that continues once the public health emergency ends. So Bob, Kristen and I are going to wrap up there and turn it back over to you. And we're happy to answer any questions that you have or that participants have in the time remaining on the call.
Great. Tom and Kristen, thanks for that excellent overview. I will quickly turn to Dr. Elaine Rotenberg. There's a few questions. I invite others to put questions in the chat box. Even if we don't get to them today, they'll be good for us to know that these questions are on your minds for future consideration. So Elaine, please.
Great, thanks, Bob, and thanks, Tom and Kristen. It was a great overview. I think some of the general questions that the clinicians had were mostly clinicians who were really worried about the repercussions if they discuss issues related to abortion with clients in a clinical practice. And so I guess the overarching question would be whether a mental health clinician can be at risk, and if they're talking about abortion, if they are documenting and how to document conversations about abortion with their clients. Maybe you could speak to that. I think that's the overarching concern.
Dr. Rotenberg, I can take that a little bit. So I think if the threshold question is, could I be at risk? I think unfortunately, I can't say no to that question, even though I think legal theories that would hold, for example, a mental health clinician liable for aiding and abetting, I think they're extremely far-fetched legal theories, but it's not that you could completely avoid someone trying to advance them. So I think for clinicians who are talking to patients about abortion, potentially implicates the aiding and abetting liability issue that I touched on earlier. And the question of what does it mean to aid and abet an abortion? I think it's unlikely that counseling a patient about their feelings about an abortion would legally constitute aiding and abetting the abortion, but that does not mean that doing that is completely risk-free. I would just point out that obviously mental health clinicians provide counseling to patients that engage in other unlawful activity. I think patients with substance abuse disorder is an obvious example. You have patients who talk to their clinicians about recovery or their struggles in recovery, and in doing that, they're talking about unlawful activity. I think where we have a difference here is that again, you have these other people who may have an interest in preventing the unlawful activity without sort of the constraints of a police budget or attorney general's office resource constraint. And so there is sort of a wider risk profile. It is possible that law enforcement could subpoena health records subject to the defenses that I discussed before. And it's not beyond the realm of possibility that someone who's particularly zealous in a state with particularly restrictive laws could pursue any and all legal theory, no matter how far-fetched. And that state courts that are tasked with enforcing these restrictive laws could be, I just got a note about gambling. Gambling is another example that is legal in some states, illegal in other states. I think about marijuana use as similar, which is legal in some states and illegal in other states too. So yeah, the state courts might find you may have some sort of rogue judge, like I talked about before, saying that somebody is liable for aiding and abetting. That being said, I don't think counseling generally meets the legal standard for aiding and abetting liability. And I don't think anything about these laws changes your ethical obligations to keep whatever records you would normally keep about a patient interaction. I think if you're doing everything short, if you're not actually assisting a patient in a state where abortion is illegal to get an abortion, you're doing a good job of protecting yourself. But unfortunately, the risk profile for this particular activity is just really different because of the different law enforcement mechanisms that are at play.
Thank you. So you're not suggesting then that therapists protect themselves by, let's say, not documenting the word abortion, not speaking to that, using more vague terms when discussing kind of family reproductive questions?
I think that the obligations for record keeping and documentation have not changed, but my understanding of those obligations, is that the different clinicians do have discretion and use their judgment about how they document their interactions with their patients. And so they can use their judgment, but I wouldn't advise to do anything other than what in your judgment is ethical for your documentation of patient interactions. I hope, I know that's not entirely clear. I just think clinicians need to document their interactions as they see fit.
Thank you. Thank you. And I guess a related question, and we'll see, I don't know if other people have questions, but sort of on that same line, Kristen, is are there actions that might potentially expose a clinician to greater risk? I mean, are there things sort of in this day and age and with this landscape that would be a sort of a more global statement of like, caution yourself and protect yourself by doing or not doing blank?
And Dr. Rotenberg, if I may, I'd like to add a question on, and then we can maybe
Sure.
bring the session to an end. In addition to that, appropriately, a lot of the discussion today has been on clinicians and considerations in that respect. But in the Jewish communal world, we also have federations, we have foundations that may be considering providing financial assistance not necessarily even for the abortion, but for travel, other ancillary expenses. Do you have any comment? And maybe Texas is on a category of its own, but do you have any comment about that activity in state to other states? So if you could add that on, and then we'll bring the session to an end.
Sure. So first, to Dr. Rotenberg's question, I think there are no sort of like unequivocal ways to avoid some, you can imagine just practical ways of avoiding drawing attention to yourself, and potentially your intentions with respect to abortion care. If, and particularly, obviously, if you live in a state where abortion is illegal, it is illegal in your state. But if you live in a different state, I will just note that, Oklahoma has probably the most actually restrictive ban on abortion. I mean, it's banned in almost all circumstances, and they do have aiding and abetting liability there. But just last week, the Attorney General, who is, by no means a proponent of abortion, did go on the record about what he intended to do with respect to law enforcement for aiding and abetting. And he said that it is not their intention to go after like pro-choice advocates, right? Their intention really is to go after people who are specifically facilitating obtaining abortions. Now, I don't think he spoke specifically to the extraterritoriality issue and whether he's intending to cross lines with, to prosecute people across state lines. But there is still freedom of speech, and it sounds like, at least in Oklahoma, they're going to try to walk that line carefully and avoid First Amendment implications by pursuing people who are simply talking about obtaining abortions, right? So, what is really prohibited is providing abortions in those states and facilitating people providing abortions. So I've heard stories of people who have obtained abortion pills for family members or friends and given them to, potentially minors, things like that. Like, those are the people who may be in trouble. So relating to the question about other organizations, not necessarily clinicians or providers, I would say, first of all, that all of the very sticky, thorny legal issues around extraterritoriality apply here. So if you're outside of the state where the abortion is unlawful, and the state is kind of coming after you for something you did without ever setting foot in the state, I think there are good legal defenses to liability. But they still need to be tested, and I think they will be tested in the next coming years. Ways to insulate yourself would be, somehow, like I was talking about with the employers, like limiting access to the information about what the funds are actually being used for. So if you're just happening to provide funds for travel or food or housing, and you don't require anyone to say, like, I'm asking for this money because I need to get an abortion, that would be one way to protect yourself. And obviously limiting the provision of funds to things that are not the abortion itself may be one way to protect yourself. I also think, and this is not a well-developed area of the law necessarily, but you should consider whether there are religious freedom arguments that could be made for Jewish organizations, because I will say I've heard about this a little bit on NPR and stuff. I've heard chatter about some groups saying, hey, abortion bans actually are imposing a religious perspective on everyone else, because not every religion prohibits it, and some religions endorse family planning in all forms. So there may be arguments that would be available to Jewish organizations that may not be available to other not-for-profits that do not have a religious affiliation. And again, these are kind of untested legal arguments, but ones that you could consider as part of formulating a defense and a risk mitigation strategy.
Well, this has been great, a fantastic discussion today. Thanks to the Jewish Federation Strategic Health Resource Center for hosting this important conversation. We understand that this is likely just the beginning of many future discussions that we will need and want to have. Thank you to the network of Jewish human service agencies and their clinical net group who joined us today and demonstrated from the questions that were collected just how complex these issues are. And most of all, thank you, Tom and Kristen, for your sharing your deep expertise with all of us, helping us to achieve a better understanding about the legal risks that so many people and organizations are facing in a post-Dobbs world. Thank you for joining us today, and keep your eye on your email for future conversations. Have a good afternoon.
Thank you, Bob and Elizabeth. Thank you for your time, everyone. Bye.
Thank you.
Thank you.
You all for joining.
Bye-bye.